just want you to answer my questions. I want you to answer what you know. Either you know or you don't know. I don't want you to speculate. Are we clear?
I just answer, yes, I used to answer.
Pardon?
I have the way of answering.
Yes.
I don't know really whether I can answer like you want me to answer.
Mr. Kanyange, it's not what I want. You see, when a question is asked, either you know or you don't know.
We don't need to argue. Let us just proceed.
Or you can say you don't want to answer. You are entitled to do that as witness.
Yes, I know.
Yes. So before we start, is there anything you want to add?
No, nothing.
Okay. Now, yesterday, we were still touching on the issue of money laundering. I just want to exhaust that. In the quarter code, the first bail application, Magistrate Governor, I don't know if you're aware, he found out that in terms of money laundering, the state has a tall mountain to climb. In fact, in that regard, he indicated in his judgment that the state doesn't have a strong case in terms of money laundering. Are you aware of that?
I'm not aware of it.
Okay, if you are not aware, that is what the judgment says. I can read that out for you so that you become aware. The court can just bear with me, my lord.
Yes.
It appears in the judgment, the typed record says page 13. It's from line 10. In fact, 14. It says, it reads as follows, and I'm reading it verbatim. The applicant for these charges of money laundering under POCA, but in the absence of any other evidence, the state will have a mountain to climb to secure conviction on these cases. But I do not think the state has a strong case here. This is what the magistrate said. And this is after Mr. Olivier testified in the bail application, and he gave the reasons more or less the same reasons that you gave. The issues of the applicant's account, being deposited with money for payments and so on. This is the same evidence that was adduced. But still, the magistrate found out that the state will have a tall mountain to climb. He doesn't think they have a strong case there. So now you are aware.
That was a different bail application.
Yes, I put it to you that the circumstances have not changed. It's still the same. It's the same evidence that Mr. Olivier gave, more or less like you. The issue of money coming from Olia and the other entities into the applicant's account.
I still have a feeling that the state is having a strong case against the applicant.
Yes, I put it to you that you say you have a feeling. That feeling is not backed up by any evidence. It's just a feeling, as you said. In fact, put it further, it's a wrong feeling that you have.
It's not a wrong feeling.
Yes. And I'll argue as such. Now, let's move on. You indicated in your evidence in chief that you fear that applicant might abscond if he's granted bail. And in fact, you even stretched it further. You made a very bold statement. You said that applicant might run away to go to South Africa to stay in the house of Mr. James Hatukulipi. You recall that?
I recall.
Okay. Now, I want you to substantiate that statement of yours. I don't want you to speculate. On what are you basing that? Did you hear some evidence
I said
from
there's
somewhere?
a likelihood for him to abscond.
Yes, I want you to substantiate that likelihood.
Well,
What are you basing it on?
I based it that the applicant, he is still an employee of Olea Investment number 9CC, a company that is owned by James Hatukulipi.
What makes you say he's still an employee? What evidence do you have?
I did not get anything that say he is either dismissed, he is either retrenched, or he is resigned from that entity.
Are you aware that the applicant, from the time of his arrest, he ceased receiving a salary from Olia Investments?
Although he ceased receiving a salary, I don't think there was any change of him being registered as an employee
You see, Mr.
for Olia Investment.
Mr. Kanyangela, that's where I have a problem with you. This court wouldn't want to say you to say what you think. When you stand there in your capacity as the investigation officer, you should say what is a fact or what has been unearthed according to your investigations, not what you think or what you feel. This is the area of speculation now, which we already indicated in the rules of engagement that we should avoid speculation.
To say that he stopped receiving a salary doesn't mean that he is not employed by Olia Investment.
That's according to what you think, isn't it?
As I said, I never saw anything that said that he is no more a member.
Now let's get back to the real issue. The bold statement that you made that you will go to the house of Mr. James Hatukulipi in Cape Town. On what basis are you saying that? Is it again what you think or what you feel?
The applicant is a member of the syndicate. And if they want for this matter to be delayed, they can do anything that they can do. If the applicant get bail, he can still continue receiving instructions that you are regarded as lawful.
On what are you basing that? Before I question you further. Is it again what you think or what you feel?
The likelihood is there.
Mr. Kanyangela, this is a bail application, and a seasoned officer like yourself should be well aware that even hearsay evidence, to a certain extent, is admissible in a bail application.
I know.
Did you perhaps hear from somewhere that if applicant gets bail, he's planning to run away?
I did not hear that, but I know that in some cases, applicants were given bail and they ran away.
You as a seasoned officer, you should know that every case must be taken on its own merits.
I know.
So leave the other cases. We're talking about this particular one. On what are you basing your bold assertion that if applicant gets bail, he will run away, go to stay at the house of Mr. James
I
Hatukulipi?
said I do have experience that applicants or accused persons who used to be given bail, they used to abscond.
Okay, that is other cases.
Yes.
Don't you have experience of other cases also where applicants who get bail don't run away?
I experienced it.
Exactly. So it's 50-50. Some will run, some will not run.
Yes.
But that is other cases. Let's get back to the case at hand. What evidence do you have, inclusive of hearsay evidence, that applicant indeed will abscond if he's granted bail? That is the crux of the question.
The crux of the question is like that, but you also don't have evidence to say that this person will not abscond
Mr.
if he's given
Kanyangela,
bail.
I put it to you that clearly, again, you are delving in the area of speculation.
Okay, you can take it like
Yes,
that.
I put it to you and I'll argue as such. You will do and say anything, including what you think or what you feel.
It's your duty to argue.
We set the rules of engagement. Let me finish and then I'll allow you to talk. You will do and say anything, including what you think or feel, just to twist the arm of the court, not to grant bail to the applicant. You've just demonstrated it because you failed to back up your bold statement that applicant will abscond and run away to South Africa.
I don't have that power to twist the arm of the court.
But that is what you are trying to do, because when you make a statement as the investigation officer, you must substantiate it. And you failed to do that.
That is what you are speculating.
I'm not
Yes.
speculating. I'm saying,
Yes.
and that is what I'll argue. Prove me wrong by backing it with facts. I'm giving you the opportunity now. Prove me wrong. Back it with facts. This is your opportunity.
I have already explained.
Yes, and what you have
Yes.
explained is illogical logic. Do you have evidence that applicant has ever been to Mr. Hatukulipi's house in South Africa?
I don't have that evidence.
Do you have evidence that applicant knows any of the co-accused apart from his former employers, Mr. Hatukulipi and Mr. Shangala? That he knew them before this case?
I'm not aware whether he knows others.
Exactly. So you are blank. But here you are parading to this court. When I say blank, I mean in that score.
My Lord, it is also rules of this court that a legal practitioner, even in cross-examination, must be courteous to the witness. This continuous insults to the investigating officer that his logic is illogical, his blank are so unnecessary and do not assist his cross-examination in any way. He can pose questions, but it does not need to include any insults.
Okay.
My Lord, I take offense with my learned colleague. That is not an insult. Saying illogical logic, I've established a basis. It's not an insult. When I said blank, means there is nothing that has been put there. And I didn't even finish. My learned colleague sprang up.
Because I heard you later on trying to put it into context.
Indeed so, my Lord.
Well, initially I also somewhat got concerned about whether the word wasn't harsh. But you confirmed that you are aware that you ought to be courteous to him, that you are aware, right?
My Lord, I am fully aware, and that is exactly what I'm doing.
All right. Thank you, Mr. Siomunji.
May it please the court. Mr. Kanyangela, before I was interrupted, I put it to you that you are blank on that issue of whether the applicant knew the other co-accused apart from Mr. Hatukulipi and Mr. Shangala. You are blank on the aspect of whether applicant has ever been to the residence of Mr. Shangala in South Africa. But here you are parading a narrative that if applicant gets bail, he will run away there. That's the issue that I said you are blank on that score. Means you've not been able to provide evidence to the court. No answer. Let's move on. Now you said applicant is a member of the syndicate. I'm sure you agree with me that racketeering is dishonest and fraudulent business dealings, isn't it?
That's correct.
Yeah? And a racket is an illegal, dishonest way of making money. So a racket can be a syndicate, isn't it?
Yes, it can be.
Okay. Now, you already indicated you have no evidence that applicant knew any of the co-accused, apart from Mr. Shangala and Mr. Tukulipi. We already established yesterday that your star witness, Johannes Stephenson, didn't mention the applicant in any way through either his affidavit or any correspondence, isn't it?
That's correct.
Yes. So in which way now is the applicant a member of the syndicate as you want to parade him before this court, where you have no evidence that he knew any of the co-accused? He's not mentioned by your star witness. In which way?
But you know James and Saki.
We already canvassed that yesterday. Those were his employers.
Yes, but he knows them.
In which capacity? Maybe let me explore that from you, since you investigated this matter. In which capacity did he know them?
He knows them as his employer.
Exactly. Employer-employee relationship, isn't it? Not a friend or a colleague.
It can be a colleague, because he works also with them at the office of the Attorney General.
I don't want you to speculate. Apart from employer-employee relationship, do you know if they are friends and they used to socialize in other areas apart from employer-employee relationship?
They might know each other before he was employed.
Exactly. So now again you are delving into the area of speculation.
And
They might.
why I'm saying so? It's because I never saw any, in the investigation, we never saw any advertisement made by Olea Investment for people to apply. He was appointed directly or he was brought in directly. So he know them before.
That is what you are assuming. The issue is, we want facts. Did you investigate that matter to find out whether they knew each other or not?
I said, he had been working with the co-accused, Saki, at the office of the Attorney General. And they could know each other if they are in the office.
They could. But do you have evidence that they knew each other?
They knew each other.
Eh? You are saying they could. Mr. Ganyangel, I put it to you that clearly your testimony is based on speculations. That's why you are saying they could know each other, or maybe they knew each other. Speculation.
Lord, this line of questioning is it's taking us nowhere. The second applicant on record indicated he knew Mr. Saki Shangala from the office of the Attorney General. It's on record. Why are we pursuing this?
All right.
My Lord, my learned colleague seems he's in a hurry. He wants to re-examine. He will have his chance. In which capacity did the applicant say he knew Mr. Shangala? It's in a work relationship. He didn't say he knew him as a friend. And if my learned colleague wanted to pursue that, his opportune time was cross-examination to explore the nature of the relationship, which he dismally didn't do. So moving on, Mr. Kanyangela,
Okay.
I put it to you, it's clear you are speculating and you are going against the rules of engagement
I
that
will
we
still
established.
say that they knew each other.
Yes, you say that because for you, you do and say anything, including what you think or feel,
Yes.
just to try to demonstrate to the court that applicant 2 is not a good candidate to bail.
Maybe before you continue, because your colleague stood up and raised the issue of the second applicant, having said that he knows or he knew Mr. Shangala, is your question centered on the capacity in which he knew?
Indeed so, Your Lordship.
Okay.
Because, Your Lordship, if the court will take note, I asked the issue of, apart from employer-employee relationship.
Yes.
Yes.
Mm.
And
No, I
the
just
issue
wanted
of-
that to be clear.
Yes, the issue of the syndicate.
Yes. You may proceed.
May it please the court. Now, the communications pertaining to the Fishco case, we dealt with Namgoma yesterday. Is there any communication pertaining to Fishco, governmental quotas, or any of the sort that went to the second applicant?
I never saw any communication.
Exactly my point. So that cements my argument that second applicant cannot be a member of any syndicate because, including the Namgoma and Fishco, there is no communication that ever went to him. You have no evidence that he knew the co-accused, apart from his former employers. So you cannot indicate that to this court that he was a member of a syndicate, because syndicate are people who work together to pursue a certain pursuit.
He was a member of the syndicate because he opened an account in his personal account, in his personal name, for money from that corruption to be used into his account. And he also received money from entities which were being paid in respect of the government objectives.
Mr. Kanyangela, we already established that yesterday.
Yes.
You are not even aware whether, I will not delve into what you consulted or what you didn't. You are not informed of what transpired in evidence in chief when the applicant testified. So you are speculating.
What I know, he ended up receiving the money that came from the government objective quotas.
Mr. Kanyangela, we canvassed that yesterday. The issue of the applicant receiving money is not in dispute. And I showed you the files where each and every payment has been explained. That information was not conveyed to you by your lawyer. It was not.
That's correct?
Yes. So you cannot fault anyone apart from your side. And that's why I'm explaining to you that even the issue of the accounts was explained by the applicant. You didn't know that. You didn't even know whether 713,000 out of that money was actually the salary. You indicated yesterday you didn't know. So you are not in the know. That is why you are speculating. Let's move on. The court can just bear with him, my lord.
Yes.
You recall yesterday there was an issue that was raised pertaining to, I think, ammunition. You said, I think it's how you understood it, that applicant could not have had permission to possess ammunition because in order to do that, you have to get a letter from the Inspector General. You recall? I'm paraphrasing.
I said the license holder had to make a statement, and
Yes.
that statement had to be taken to the police for endorsement. Then is when the permission will be given.
Exactly. But the applicant never testified that he had permission to possess ammunition. His testimony was very clear. He said there's a letter that was written by Mr. Shangala where he's allowed to go and buy ammunition for Mr. Shangala and also for Olia Investment number 9cc, which also owned firearms. That's what he testified.
I don't know what he testified, but if the letter is for James and Saki, for them to go and buy ammunition, it will not give him permission to be in possession of such ammunition.
Mr. Kanyangela, that's why I indicated that it seems most of what was testified by the applicant was not conveyed to you. So I actually sympathize with you. Court can just bear with me.
Yes.
Officer, if you can just give the witness this exhibit. My lord, I'm referring to UU 43. This is an extract. If you look there, it's from the accountants. The accountants that were in charge of Olia Investment number 9cc. If you can just read on top, there's a name.
Yes, I see the name.
What is the name?
BZ Accounting Services.
Exactly. So this is part of the disclosure that we received, but this part is what Mr. Van Wyk testified about when he indicated that Mr. Hatukulipi, Mr. Shangala had accounts with Olia and also their entities. They used to receive money and also borrow money from the CC. And this is proof thereof. They had accounts with Olia. But what I want to show you there is, if you can turn on, it's not numbered, but page, if you can just page through number 10. It's double-sided. No, but no, just
What number 10?
10. Just go through like 10 pages, but on the other side. Are you on number 10?
Possible, yes.
Do you see any transaction that deal with ammunition? Something about, I think it's 21 April or so, if my memory serves me correct. Transaction that deal with ammunition.
Let's do it this way. Officer, just hand the document to Mr. Siomunji. You can just mark on the side for him.
In this, I'm indebted,
Yes.
my lord.
So you indicated that is the 10th page.
10th page, yes, my lord.
As you
It's
are
not
doing.
numbered 10th
Yes.
page, but because it's double-sided.
Yes.
So if you count the double sides,
It will be 5.
no, 10.
Okay, 10
Yes, but on the other side.
on the other side.
Do you see those transactions of April?
Yes, I can
Indicating
see.
gun shop.
I can see them.
Yes. So those transactions were done by Mr. Van Wyk. So there are various transactions there for the gun shop with regard to purchase of ammunition. I'm sure you can see them, isn't it?
Yes, I can see them.
Yes. So I purposely went there to show you, this document is an exhibit before the court. Show you that it was not peculiar, it was not strange for Mr. Van Wyk to go and buy ammunition as per the authority given a letter by Mr. Shangala at the gun shop.
Mr. Shangala is not above the law. Even if you have to go and buy, you still have that permission from the office of the Inspector General.
Mr. Kanyangela, you are not in possession of that letter, isn't it?
I'm not in possession of the letter, but that is what the act saying.
And what I'm informing you is what the testimony of Mr. Van Wyk was, that there is a letter that was given to the gun shop. And that letter enabled him to go and buy ammunition on behalf of Mr. Shangala and Olia Investment number 9CC. It was not disputed. I'm sure you are not aware that there
Maybe
was
you
such
can
testimony.
convince me if you show me that letter.
That is what you are asking now, is what should have been disputed in cross-examination to show that if there is such a letter, then that letter should be produced. That was not indicated by your mouthpiece, my learned colleague, in cross-examination. It was not.
And if there one, that is why I say maybe you can show it to me, then I can comment on it.
Mr. Kanyangela, you as a seasoned officer should know court procedure. Whatever is in dispute at that point when a witness is testifying should be disputed in cross-examination. That piece of evidence was never disputed in cross-examination. In fact, it went unchallenged until the applicant, finished with his evidence.
Whether it was unchallenged. Yesterday you were giving me letters here. But you can still do the same.
Let me just understand this issue. So it was the applicant's evidence that there was a letter given to the gun shop allowing him to purchase ammunition
Indeed, so,
on
my lord.
behalf of his employer.
Indeed, so, my lord.
Okay. Now, I just want to hear Mr. Kanyangela's comment as to whether this consent by the Inspector General still applies under those circumstances. Assuming that's what happened, there was such letter to the gun shop. Is your answer still the same, that there's still a need for the Inspector General to be alerted of this fact?
That's all, my lord.
Would you like to elaborate?
If the person have to I don't know whether I can say it, to be in possession of ammunition or to go and buy ammunitions, there should be an application to be made to the office of, a statement to be written and submitted for endorsement. And that permission can only be given to a person who is acting under the authority of the Inspector General.
Okay, you may proceed, Mr.
May I please the
Simonzi.
court? If that is your stance, why didn't you give instructions to your lawyer to oppose the issue of the letter that was indicated and proof thereof to be provided to find out whether indeed permission was sought from the Inspector General?
My lord, the evidence from Mr. Nigel Van Wyk is clear. He didn't say he received a letter from the Inspector General. He said he received a letter from Saki. And that I accepted that. That is a letter from Saki, and it's of no relevance.
Okay.
Because the procedure is the letters must be from the Inspector General. Why should I cross-examine on non-issues?
Well, also, thank you. And in both instances, I believe this is a matter of law which council can dwell with, whether it's a letter from the employers directly to Mr. Van Wyk, or a letter from the employers to the gun shop. On those sets of facts, council can still advance arguments as to what is the law that prevails.
May I
So
please the court?
I'm just saying that it's well captured. Council can argue about it as to what is the position in law.
May it please the court? My
Yes.
lord, the issue I was just outlining to the court is,
Yes,
if one says he received a letter from the employer,
yes.
if that issue is in dispute, then it should have been challenged in cross-examination, and questions should have been asked like, is your employer the author of the letter? Did he get it from somewhere? Or we want to see the contents of the letter to see whether it complies with the lawful requirements, and so on. That is what is done in cross-examination if that issue is in dispute.
And you are saying that there was none
There was no issue. There was no dispute raised on
done?
that
Okay. I see
issue.
your colleague standing.
My lord, this is not the state's application. It's the onus lies on the applicant.
Okay.
If he wanted to provide further information to the court, he
Okay.
didn't need to wait for cross-examination. I was satisfied that the letter was issued by Saki, and that was not in compliance with the law. I will argue it.
Okay.
There was no dispute. Why should I have disputed it?
My lord,
Thank
case law is very clear that when an applicant says something, the state doesn't play a passive role. The purpose of cross-examination is to test the evidence. So if something remains unchallenged in cross-examination, it should be
Okay.
accepted.
No, I hear you, Mr. Siomunji.
May it please the court?
You may proceed.
So if you can just give my documents back. But just to indicate to you, Mr. Kanya, I gave you that. In fact, were you presented with that document?
It's the first time to see it.
It's very interesting that you are testifying on behalf of the respondent, but it's your first time to see this. The same way it was your first time to see the other files of each and every payment. The purpose of this, and Mr. Van Wyk went through this document to show that there was proper records. There was an accountant, there was a bookkeeper, there was an accountant, and everything was audited. That's the purpose of this. It was not challenged. So it's so shocking and appalling that actually you never got to see this.
My lord, this statement, my learned friend says the thing is from the docket, from the disclosure from the state, from the investigating officer.
You mean that very
That document.
UU 43?
Yes.
Okay. All right.
My lord, the issue
Maybe
is...
maybe the issue seems to be the sort of innuendos that accompanies the questions. In other words, your colleague's plea is that rather just put the questions, and what may be argued will be argued, but the statements such as it's strange, it's appalling, those are the issues that are making him to stand and say, maybe how is it appalling if you are just saying that it's in the docket.
My lord,
If you can limit those and just question the client, and the rest you will really argue to say, well, it's very strange that Mr. Kanyangela did not was not aware of these issues. So I'm just advising to say, perhaps limit the innuendos that are accompanying the questions.
may it please the court. My lord,
And
I
that's what your colleague also tends to stand and say, you are not really very courteous to the witness.
My lord, I take the court's guidance. However, the court will also know that in various plethora of cases,
Yes.
the issue of cross-examination has been
Yes.
dealt with.
Yes, you are
When
right
I say
about that.
shocking and appalling, my lord, I don't mean that with any insult.
Yes.
But when I say shocking and appalling, my lord, is clearly when an applicant has testified, he has put versions before the court.
Yes.
Surely those versions, in preparation for the testimony of the respondent, the investigation officer, what the applicant has testified, surely it is expected
Yes.
that that version should be informed to the investigation officer in preparation of his testimony.
Yes,
So
I
that is
agree.
the shocking part, my lord, because if the court will, bear witness, even the issue of, your lordship, the files
Yes.
for the payments,
Yes.
we went through a tedious exercise of explaining each payment.
Okay.
But those things, of course, are not part of the docket.
Well, I follow your,
Yes.
your argument very well, but would you say it takes away from your good case if you do not remark as such?
My lord-
It does not.
It does not, yes,
Yes.
indeed so, my lord. But the point I was just stressing,
I
my lord,
understand.
is it seems Mr. Kanyangela is in the dark
Yes, and he's-
about what
and-
the applicant testified,
and
because
he's clear on something that he does not know. He's saying it's the first time I'm seeing it, which is very clear. And then you can ask your next question. I just do not want it to appear as if we are not very courteous to witnesses. And as an officer of court, I just remind you of that. I haven't picked it that you have crossed the line, but I'm just bringing it to your attention that it's what has led to your colleague standing up and
may it please the court.
yes.
Moving on, Mr. Kanyangela. One of your grounds of objection that you indicated that you fear that the applicant will interfere, is it with the state's case?
That's correct.
Now, my learned colleague indicated that he feared that applicant will interfere with state witnesses. State witnesses, the case, more or less the same thing. But are you aware that when Mr. Olivier testified in the initial bail application, maybe before I get there, you also indicated that you fear that applicant, you already indicated applicant will abscond. That you did say already. Now, Mr. Olivier, when he testified in the initial bail application, page 67, the typed version of it, when he was asked if applicant is a flight risk, from paragraph 20, he was asked by the erstwhile legal practitioner of Mr. Van Wyk that, is he a flight risk in your opinion? Is he a flight risk? And this is the response of Mr. Olivier. He responded, the accused person, according to my observation, he is not a flight risk.
That was his testimony.
Yes.
That was his version, not my
Yes,
version.
and Mr. Olivier gave more or less the same information as you. The issue of the accounts of the applicant being used and so on and so forth, more or less the same thing that you testified.
That was I said. That is his version,
Okay?
and not my version.
So that means, in fact, there's like a difference in terms of your stand. You people belonging to the same entity, ACC.
Yes.
He said he's not a flight risk. You are saying he's a flight risk.
You can draw the line where you want to
Yes.
put
So
it.
I'll argue that actually there is confusion
You
in
can
terms
argue.
of
That is your duty
your
to
camp,
argue.
because you do not even know what it is that you want to stand for. Your colleague saying that applicant is not a flight risk. You are saying is a flight risk, and you have actually no backing, no basis to say that.
Would you like to rest the issue?
No, my lord.
You were doing an exchange. He's done asking the question. Would you like to comment any further? No, simply to say that two officers from the same institution appears to say something different. In other words, one says he's not a flight risk, and you are saying he is.
My lord, it's two different people who are saying. And every person is having his own thinking, or his own, he can make his own version. So if Mr. Olifield said that he don't see any flight risk, he did not say it on my behalf. To me, I still see that he can be a flight risk.
Mr. Olifier said it in his capacity as an ACC officer.
That's what I'm saying. That is just what I explained.
That's fine. Let's move on. Further, Mr. Olifier was asked whether there's a fear of interference with witnesses in this case, or if the applicant had interfered. And this is what he said on page 70 of the typed version. All right, did he interfere with any witnesses that you know of, or either in this matter or the so-called Fishrot matter or Fishrot matter? And he said no. So there was no fear of interference with witnesses.
Yeah, for him
Mr.
there was no any fear of interference, but to me,
But for you it exists.
he have already interfered with the officers when they went to arrest Saki and James. That is interference with the case. And those officers, they are also witnesses.
Mr. Kanyangela, I'm sure you agree with me that by the time this bail application was done, the initial bail application, by the time Mr. Olifier testified, already there was that allegation of interference with the officers, isn't it? The case was already registered.
Yes?
Yes. But in Mr. Olifier's view, there is no fear of interference with witnesses.
That is his view.
Yes. I put it to you that you are just saying it's his view because you have not been able to substantiate your ground. And in fact, I stretch it further by saying that, in fact, at this point where investigations are done, they were not done that time. It actually cements my argument that the fear is not there. You said you are done with the investigations, you are ready for trial.
Yes?
Yes. You further mentioned, maybe before I get to that, you indicated that you have a strong case. State has a strong case against the applicant. Do you recall that?
Yes, I recall.
The court can just bear with me. You were asked a question about a plea deal by my learned colleague, if you are aware of any plea deal that was done, and your response was that you are not aware of it. Do you recall that?
That's correct.
Okay. Just want to show you certain documents. Apologies, my lord. I just want to locate
Yes, it's fine.
those documents. My Lord, may I just approach the applicant? I can't find.
Yes, you may do that. You may do that.
My Lord, I can't find my document, but these were already marked as an exhibit.
Okay.
Officer, just give it to Mr. Kanyangela. You don't have to read this into record, but you can just read just for your own understanding. Before you do that, were you ever presented with these documents? Since you indicated you are not aware of any plea deal.
I was asked whether I was involved. Then I say I was not involved.
Or you are not involved, but were you ever presented with these documents? Before today, that is.
Is that the plea deal?
Indeed so, my Lord.
Okay.
I was presented with one, but let me just see whether it is the same document.
Just check and see if it's the bundle just as it is.
No, I only have one.
Okay. Yeah, but let's concentrate on what is before court. The bundle as is.
Well, it seems he's trying to look into his documents to compare whether he might have been
May it please the court.
presented with one.
Seems the one it was given is not part of this bundle.
Okay, it's fine. Now look at that bundle. That bundle is before court. You can go through the first letter. What does it say? You don't have to read it into record, but according to your understanding, you can read it and just say what you understand by that.
So, Mr. Kanyangela, your reply to the question whether you were presented with those documents, what will be your reply?
I said they were not presented to me. I only was presented with one, but it is not among these ones.
Okay.
So, again, I cannot say much as to why that thing was not presented to you. I don't want to make assumptions. All I can say is that you as the investigation officer, it should have been presented to you. But nevertheless, let's move on. Now, just go through that first letter. What are the contents of it? You can just paraphrase. I don't want you to read it into record.
Case the Office of the Prosecutor General that is confirming or the considering the plea that was being offered by the applicant.
Okay, that's what it says. Check the next document. What does it say?
Next page or next document.
Next document. Maybe before you get there, the plea, okay, according to that letter, the plea that is being offered, but what is the Office of the Prosecutor General saying about that plea?
They say the applicant to plea on one count,
Which count is that?
which is a common law offense of attempting to defeat or obstruct the course of justice.
Okay. What does the next document?
Okay, the document says the applicant did never offer to plead guilty.
Okay. Now, looking at that, of course I sympathize with you, you never saw those documents before. But looking at that, I want to marry it with the issue that you are parading yourselves as the state that you have a strong case against the applicant. The consideration, according to the first letter, is that applicant should plead guilty to common law assault. I'm sure you agree with me that the charges that applicant is facing, as per the indictment, is first count of racketeering, count 2 also racketeering, count 3 money laundering, count 4 money laundering, count 12 unlawful possession of ammunition, count 14 assault, resist, or obstruct an authorized officer, count 40 theft, count 41 money laundering. Very heavy counts. If indeed the state has a strong case against the applicant, why is there even a consideration for the applicant to plead guilty on common law assault? If you know, this is if you know, before my learned colleague stands up, I'm asking this question, I'm entitled, if this witness knows.
Okay.
I'm also entitled to object, my lord.
Yes.
Yes. If he knows, my lord, the witness have already testified. And he testified that he doesn't know of the considerations that were given. Whatever opinion that he will form with regards to that will be of no assistance to the court. That is, at the end of the day, the court is in a position to make its own opinion. And it will be an irrelevant opinion from the witness, and it need not to be on record.
So, what is your objection? Is it to say that
It's
the witness already
eliciting
indicated that he is not aware of the plea deal?
Yes, of the considerations given to the plea deal. It was between the state and the accused person,
Okay.
being the office of the
So, in
prosecutor.
other words, he cannot be of assistance to the court.
Whatever opinion he will give on that score will not assist the court in any way. And that is exactly the kind of opinion, evidence that is not relevant and admissible onto the record.
Okay. Thank you. Mr. Siomunji?
My lord, I am being fair to this witness, and that's why I said, if he knows. I'm not asking him to speculate. My learned colleague is in a hurry to always just object. I said, if he knows.
Yes.
If he doesn't know, you can just simply say he was not involved and he can't say anything further, and I'll leave it at that.
Okay. Well, let me allow the question.
May it please the court. Mr. Kanyangela, and this, I don't want you to speculate. This is only if you know. Remember our rules of engagement. Say what you know only. If you don't know, it's not a crime. And you can also refuse to answer the question. Now, I'm asking this question in light of the narrative that is being paraded before this court, that the state has such a strong case against the applicant. Now, it flies in the face of even considering a plea on common law assault, considering the heavy charges.
It's not assault, my lord. The letter is clear. Obstruction.
Is it attempting?
Common law obstruction. I'm indebted to my learned colleague.
Is
Okay,
it
common law obstruction.
Is it common law obstruction or common law? Is it an attempt to interfere? Because I earlier on heard you saying as if it's an attempt to interfere.
No,
Which
my
one
lord,
is the
it's common law. According to the letter, I don't have the letter here, but Mr. Kanyangela can assist. What does it say?
It is reading common law offense of attempting to defeat or
Attempting to
obstruct.
defeat the cause of justice. So my learned
Okay.
colleague is equally
Alright,
wrong.
That's fine now. Do you understand the question, Mr. Kanyangela?
Yes, I understand, my lord.
You have any comment?
The comment that I'm having is only that to say, as an investigator, I can see the state is still having a strong case against the applicant. As far as I know, there was no any charges withdrawn from the indictment. And I can say the state will not only be having a strong case if this person is acquitted from those charges, but as we are now, the state is having a strong case.
Mr. Kanyangela, I put it to you that if indeed that was the case, there is no way the state would even entertain the idea of offering a plea on common law obstruction. There is no way. And I'll argue at the end that that set of documents actually demonstrates that tacitly you've conceded that you don't have a strong case against the applicant. That is why there was that attempt of that plea.
I was not part of the attempt.
It's fine. But it's a pity it was not brought to your attention. But it was brought to your attention before this court. It's an exhibit before this court. Officer, if you can just give me my documents. Please, the court. Now, was there any demonstration? You talked about demonstrations that were done. I take what you said. I don't want you to repeat what you testified, particularly when the counsel for the first applicant questioned you. But my question is this. Was there any specific demonstration against the second applicant, Mr. Nigel Van Wyk, that he should not get any bail? And I want you to listen carefully. That's why I said specific demonstration, petition, or any other kind of issue raised by the public that we do not want Mr. Nigel Van Wyk to be granted bail. That is my question.
There was none for that.
Thank you. My Lord, I'm winding up.
Yes.
Mr. Kanyangela, just bear with me. I just want to refer you to one document. You've touched on it already, the Poll 17.
I have one.
You have one? Oh.
Unless it's not the same.
Just compare.
If it's not the one they questioned me yesterday,
It's the one. You have a copy?
that is the same.
Okay. Now, when applicant testified, letters from the Ombudsman's office were handed up, their exhibits before the court, and he said that he had never seen the Poll 17. The same Poll 17. In fact, there's a letter from the Ombudsman office where investigators from there requested the police to provide this Poll 17, and that was not done. That was his testimony.
May I find out, is Paul 17?
Poll 17, yes, my Lord.
Was it an exhibit?
Yes, my Lord. It's the double V1.
Okay.
It's double V1, my Lord. That was his evidence, which was not challenged. In fact, letters backing it from the Ombudsman's office and so on were produced.
That is misleading, my Lord. We extensively dealt with the witness. We gave him the Poll 17, and he also agreed that he's the one that signed that Poll 17. It's on the record.
So is that to say?
To say that it was never disputed that he never had a Poll 17.
Okay.
My Lord, I still stand by what I said, including the letters from the Ombudsman's office. The part of the testimony of the applicant said that letters were written, and there are exhibits before this court,
Yes.
where he, through the Ombudsman's office, the investigators there requested for the Poll 17, but it was never provided.
Okay, so your position is that the applicant never saw Paul 17.
Indeed so, my lord.
Okay.
And then this particular document, V1, when he went through it, he even said that there appears that there's 3 different types of handwriting. If you can look at the first page.
I don't know whether he may comment on the first aspect of saying, well, the applicant's testimony is that he did not see or he never saw that document. Was that complete, or because I thought maybe he could comment?
I follow the line of thought of the court, but maybe I'll ask it differently.
All right.
Was that part of the applicant's testimony ever brought to your attention that he indicated that he never saw the Paul 17, and the letters that were written to the Ombudsman's office requesting the Paul 17, were they ever brought to your attention?
Yes, the Paul 17, yes, it was brought to my attention. But I was not informed that he said that he did not see the Paul 17.
Okay.
Maybe what you can assist me with, is he also saying that he did not sign on the Paul 17, the signature that is there? Is it not for him, or?
That he didn't dispute, but I'm saying he said he didn't see, and the basis of that, if you look at the first page, I'm sure you agree with me. Look at on the first page. You agree with me that there's 2 different sets of handwriting, isn't it?
I'm not a special analyst on handwritings.
On face.
I'm sorry, Mr. Siomunji. When you say you are aware of the Paul 17, of the issue about the Paul 17, what is it that you are aware of in the context of the question that is asking?
My Lord, I was shown this Paul 17, and I am aware that there was an investigation done by the Office of the Ombudsman. But if he's saying he did not dispute that he have signed the Paul 17, if he say he did not see it, how can somebody sign something that he cannot see? He saw the document.
Mr. Kanyangela, you are asking questions.
No, I'm just explaining. For him to sign this document, he saw the document.
And I put it to you that those are the kind of questions that should have been asked in cross-examination over this document.
If
on
it
that
was-
aspect.
It was not asked, but what I'm saying is that a person cannot sign something that he cannot see.
Mr. Kanyangela, all I'm saying is, remember, we canvass the issue of cross-examination.
Yes.
Is to test the evidence. And such kind of questions are questions that are asked in pursuit of testing the evidence in cross-examination. So if that was not done then, you cannot do it now. Applicant testified and closed his case.
My Lord, is my learned friend saying the applicant was never questioned on the warning statement? If he's saying so, then he's lying. And it's not necessary for him to be lying before this court. I mean, the state went to an extent that even the court had to stop the state to say, is it really worth an extensive questioning? How will it help with the court's determination on the issue of bail? It's on record.
So you are saying that the state took up this issue
Yes.
in cross-examination?
And it's on record as from page 782.
My Lord, what is good for the goose should be good for the gander. My learned colleague stood up and he said, I must be courteous to the
Yes.
witness.
Yes.
He just used unpalatable language that I'm lying.
Okay.
The same person who cried foul.
Let me refer it back
May it
to
please the
you
court.
and hear his comment. Mr. Ipinge?
Black is black, white is white, my lord. Mr. Siomunji purposely said that the state did not deal with this issue of the warning statement. That is a lie. Perhaps he should stop lying so that I do not make such comments.
Okay, I'll rule on the issue. You see, how I understand it, well, it's language, it's vocabulary. But lying will be associated with sort of awareness about what you are saying. Not being true is something different. So I find the word to fall within the perimeters of what you asked of him to be courteous to the witness. Would you agree that lying and not true are different in this
I
context?
stand guided by the court, my lord.
Okay.
Indeed, perhaps the word is strong.
Yes.
I retract it and I apologize to my learned colleague.
Thank you, Mr. Ipinge.
May it please the court. So, Mr. Kanyangela, if we look at that, of course, you said you are not handwriting expert, neither am I.
Okay.
But on face value, just looking at it from a lay person's point of view, page 1, one can see that the handwritings are different.
That's correct.
Yeah? And if you look at also further, from page 2 onwards, you can see it's a different kind of handwriting, which is consistent up to the end. You agree with me? On face value.
Yes, that's correct.
Yes, so it's like this Paul 17 was filled in, it's like by 3 different people. Because on face value, we're looking at 3 different handwritings.
On
and
face value, I can see the first part was written by one person. The second part, that is in small letters, later on I can say it was written by a different person. But the rest, to me, it was completed by the first person.
Okay, now,
So only the second page was completed by a different person, but the rest would have been completed by, the first page and the other pages, excluding the second, would have been completed by the same person.
Yes, that's what I'm saying, my lord.
Okay.
is that procedural?
We talk of different handwriting.
Yes.
People
So-
are having different, they can write differently. I was not there when the person was charged. I was not there.
But you agree that it's different handwriting. So I'm saying, is it procedural?
I don't know whether it was done by different people or it was done by one person. But if it was done by one person, it can be possible. I can put many handwritings on one document.
Did you investigate this? Or is it only coming to your attention now, the issue of the handwriting?
It was not part of my investigation. I was not investigating that document. You have already indicated it's the ombudsman that was investigating.
No. Sir, you didn't listen to what I said.
There was nothing for me to investigate this document.
Sir, the ombudsman comes in terms of providing this document, not investigating this document.
There was no need for me to investigate it.
I didn't ask you if there was a need. I just asked you whether you investigated or
I
not.
did not investigate the document
Thank
because
you.
there was no need for me to.
Thank you, Mr. Kanyangela.
Let
And-
me hear him, Mr. Siomunji, on your question. Say if 2 people completed the document, whether it will be procedural.
This person was charged by the police. ACC doesn't have any power to charge anybody and to complete the document. So I cannot really say, because it is not in line of my duty. That is a police issue. And I don't know whether it is procedurally or it is unprocedurally within the line of the police duty.
Fine, Mr. Kanyangela, I will not press that further, but we'll take that issue up. Mr. Kanyangela, I put it to you that it is not in the public interest for second applicant to continue being in detention, second applicant being a member of the public, second applicant being a husband, a father, and especially that he is innocent until his guilt has been proven in court, to continue keeping him in detention. What is your comment on that?
The applicant, as I already mentioned, is a member of the syndicate that have benefited from the money derived from the government objectives quotas that was supposed to be to the beneficial of all the Namibian people, but it was only benefited to few.
Mr. Kanyangela, I believe we canvass that.
The public will be interested in it since they were also affected.
Mr. Kanyangela, from your own Deloitte report, you saw that you read out from yesterday, applicant benefited 0 in his personal capacity.
I told you there were 2 pages.
Yes, and every payment, I know what you mean, but I'm talking about what we canvassed. Every payment that was received in the applicant's account was accounted for.
My Lord, is it necessary to repeat the cross-examination from the beginning again? I mean, those questions have been exhausted.
Okay, thank you, Mr. Ipinge. Let me
My
hear.
lord,
Mr.
my learned
Siomunji.
colleague, I am
No,
closing.
Just a moment, Mr. Siomunji. You were still talking, so you were not yet done. I'll want to hear where you were going.
May it please the court.
Okay.
My lord, I'm making closing.
No,
Yes.
the issue that you were raising.
So as indicated in closing, the 1,940,000 that you said he benefited, he did not benefit. We provided that evidence. It was in the scope of his work. Of course, you are not privy to the files. It was not, that information was not given to you. And that's why I put it to you, that it is not in the public interest, nor in the interest of the administration of justice, for a man who has not benefited from this, evidence is there, to continue being kept in detention.
I don't know why you think that he was not benefiting if he was getting a salary, as you have indicated. And this salary was coming from the co-accused.
Mr. Kanyangela, a salary is for a person who is working lawfully is entitled to a salary, isn't it?
That's correct.
Yes.
Yes.
So you cannot say he benefited. It's a salary, it's an entitlement.
But for him, it came from a proceeding of a crime.
And we
Process of crime.
established already that you cannot say before this court that he knew the source of funds. He was an employee. He didn't know where the money was coming from. He followed lawful instructions, period.
Whether he knows, whether he didn't know, he have benefited.
Yes, I put it to you in closing now, finally, that you have just demonstrated to this court that you will go at any lengths to indicate to this court or to hoodwink this court, to twist the arm of this court, that this court should not grant bail to the applicant, but you fail to substantiate your claims.
This is not the first time I'm testifying.
My lord, that is all for cross-examination.
What is your answer? This is not the first time you are testifying.
Yes, it's not the first time I'm testifying, and I have testified similar facts that I just put before this court.
Have you ever testified against the applicant?
This is the first time.
Thank you. May it please the court.
Thank you, Mr. Siomunji. What I'll do is, I think it's better at this stage that we break. because it will be re-examination. I don't know whether you are prepared or ready to re-examine, or I should allow you to arrange, because you certainly from your side you were two, and Mr. Marondeze is the one that started with the first applicant.
Yeah, but
So
from my
I'll-
side, I don't think there's anything to clarify. We will not re-examine on the part of
Okay,
second applicant.
no, that's fine. So there will
but
be
I will
no
dis-
re-examination from your side.
No, no.
Oh, that's fine. Thank you, Mr. Ipinge. Mr. Marondeze, do you need a break, or is it time for tea break?
Yes.
My Lord,
Okay.
on the court's hands.
All right, then let's just utilize the time for the break until 12 o'clock. Then we'll proceed at 12.
The court,
May I
please.
please the court?
Thank you, Olacho. Mr. Marondese?
Thank you, my lord. Just a couple of questions for you, Mr. Kanyagya. The first one is you were asked about the procedure of acquiring quotas under a fisheries agreement, but here in this court, in this case, a memorandum of understanding between Angola and Namibia. Do you remember being asked on those questions?
That's correct.
Now, from your investigations, was there any other Namibian company or individuals apart from these people you have always used as a syndicate, the accused in this matter, who ever got quotas under the memorandum of understanding?
There was no.
Objection, my lord. That is just new evidence. There's no aspect to be clarified here. My learned friend is not delving into new evidence.
So it's not new evidence, my lord, because it's going to establish whether, if there were others, whether there was any procedure which was followed, my lord, other than what happened, what he testified as how these quotas were given. It's not new evidence, my lord.
How is it new evidence?
It is new evidence because my learned friend is not delving into the aspect of memorandum of understandings, how they are awarded in that regard. What I asked the question is, the question that I posed to the witness was, did you investigate how the procedure that is followed when awarding quotas in terms of section 35 of the Act, in terms of fisheries agreements? So now he's not clarifying that aspect, and the witness said he did not investigate that part.
Didn't you question him, or didn't you put to him how allocations were made?
In terms of
In
section
terms of
35?
Yes. Referring to the Mozambique and comparing it to the
The
Angolan
MOU, the agreement.
Yes.
Yes.
How is this question prejudicial?
It's delving into new evidence. My learned friend said, did you investigate any other people that applied under an MOU? Because there is something totally different
He's
now.
asking to say, how I understand the question is, other than the accused persons before court, whether there is any other person that would have been allocated quotas through this MOU. Mr. Marondese, did I misunderstand you?
That's correct, my lord.
Yes.
You got me correctly, my lord.
Yes. And it's also, I recall how you were asking these questions. He even stood up saying whether you were indeed saying that what obtained with the Mozambique agreement, whether you are saying that's what obtains with the Angola agreement. Unless Mr. Biekas, you show to me how this will really prejudice, because it will not even refer to your client. Yes. All right. Thank you, Mr. Biekas.
Okay. You.
Yeah, I still recall the question. There was no any other company that was given quota under that memorandum of understanding, apart from the Nangoma.
Now, we also asked a question which I feel about Deloitte and Touch. You were asked, your evidence was that yes, Deloitte and Touch were contracted by the ACC to do the investigation on their behalf. Is that correct?
Sorry, Mr. Marondese, I missed the question.
The question is, you were asked, and how Deloitte and Touch came to get involved, and your answer was that they were appointed by the Director General of the Anti-Corruption Commission. Is that correct?
Oh, okay.
That's correct.
Then you were asked further that their access to the devices of the accused persons, where they obtained this information which you had relied on, whether they had a warrant, and you said they had no warrant. Is that correct?
That's correct.
But now, in terms of the act, no, but okay, the question is now, did the ACC have a warrant of search and seizure in respect of these devices they seized?
That's correct. We were having a search warrant. It was
No.
done under the search warrant.
Yes. Now, did Deloitte and Touch have to get another warrant, or they were relying on a warrant which you obtained lawfully?
Since the devices were seized by us under a search warrant, there was no any other need for them to apply for a search warrant.
So now, do you still stand by your answer which you gave under cross-examination that yes, the Deloitte and Touch did not have a warrant? Was it necessary?
It was not necessary.
That's a re-examination method.
Thank you. I think just one question, so that I understand the Namgoma case against the first applicant. It's based on the statement by Mr. Stephenson, which makes reference to emails and some attached documents, which most of them during cross-examination you indicated that there's a possibility that the first applicant might not know, might not have known or come to the knowledge of either those emails or the documents that were exchanged between the co-accused. In the absence of those, or in the absence of Mr. Stephenson, on the Namgoma case, is there any other evidence that links the first applicant to the Namgoma case?
My Lord, with regarding to this memorandum of understanding, there were statements obtained from the Angolans and the former Minister of Fisheries in Angola also, she gave a statement.
And
in which she mentioned the first applicant with regarding to the discussions she had or the engagement they had with one another.
And you did not testify about that?
Yes, my Lord, I did not testify about that.
Okay. Is the minister your witness in this case?
That's correct, my lord.
Well, in your reply, you did not really dwell much into what the minister says in the statement. I simply wanted to understand whether, other than Mr. Stefanson's evidence relating to emails and those documents, whether from what you told the court there is anything that links the first applicant. Regarding the, I'm not sure whether this issue relates to both the Namgoma or Fishko case, where you were saying that there were developments made at the first applicant's farm. The question centered around the benefits that the first applicant might have driven from governmental objective quotas. And you were saying it's not only the improvement or the building of the dwellings on the farm. He also received money from entities that are either linked to the co-accused. There was no clarity about that. That's how it just hanged.
My lord, the benefit was from all, from Nangomal as well as from Fishko. Because,
in other words, regarding the, okay, let me just allow you to finish your reply.
because there were items that were purchased from the service providers, and those payments were coming from DHC of the money that have been now linked to the Fishko case. And the constructions or the development on the farm, all this were done most during the same period when those entities were getting money either from Nangomal or from the money that had been generated from the government objective quotas.
Okay, maybe let me make it very, very clear. You made mention of the 150,000 that was paid to the farming account of the first applicant. And he also gave a version about that amount of money. Then there is the issue of dwellings that were established on the farm.
Yes, my lord.
And he also gave a version about that. But it's when you were answering on the, or about the dwellings, when you were saying that he also benefited or he received benefits from certain entities. So what I'm saying is it did not become clear. One, what is the other benefit that you were referring to, or what is the entity?
The other benefit that he received is the benefit in terms of the materials that were being purchased for the development on the farm.
is it in respect of those dwellings, the buildings that were put on the farm?
My Lord,
Well, I think you also went on to say, or it's from his evidence, I'm not sure now, that there was also improvements made to the main house.
yes, that is as per the statement of Mr. Rudolph Van Wyk.
Yes. Because remember you mentioned the person who even did the developments on the farm. So I was just curious to know whether, other than what, is it Mr. Van Wyk, Rudolph?
There's Mr. Van Wyk,
Yes.
but there were
So-
also others who also did the development.
And that's what you were saying, and that's just how it remained. So is it helpful to the court when you say there were others, and it remains like that? You mention Rudolph and what he did, and then you say there were others, or he also benefited in some way, which you don't specify.
I can only recall few names. I can recall the name of Mr. Lucas Mupupa. He indicated that he worked on the farm. And there was also another person who gave a statement, Mr. Benny. He also worked on the farm. But I cannot now recall exactly what they did on the farm. But they provide statement of what they have did.
Do you know who paid them?
Lucas, he indicated, if I can recall, he say he used to be paid by the wife of the applicant.
And Mr. Ben?
Mr. Benny, there are documents attached to his statement, which is indicating that he used to get invoice, he used to be paid by the applicant. And those documents they were also proof to that on the documents that were seized from the farm of the applicant.
So do you then link any of the payments to the applicant's wife? No? The payments that were allegedly made by the wife to Mr. Lucas and the payments that the first applicant made to Mr. Ben, do you link them to any of the cases before court?
The payment, maybe I did not pick up the question.
Yes, you are saying Mr. Lucas and Mr. Ben did some work. In other words, they gave statements to say they worked on the
That's correct.
first applicant's farm. Mr. Lucas was paid by the wife to the first applicant. And the first applicant paid Mr. Ben. So the question is whether you link any of those payments to these cases that are before court.
My Lord, the payments were always done in cash. So it's difficult to determine as from which account it was drawn, because it's payments that were being done in cash.
Okay, thank you, Mr. Kanyangela. Just to be clear, why I asked this latter question was because this issue remained pending. You did not elaborate why you were saying there were other benefits or he received other payments. So thank you for that. That will be all. Mr. Bierkas, any aspects arising from my questions?
I have none.
Thank you, Mr. Bierkas. Mr. Marondese?
Thank you, my lord. On the, you've been asked by the Honorable Court that the emails from Mrs. Stevenson, which most likely might not have reached the first applicant. You hear that question? And that it's dependent, right? Is there any evidence which you collected in your investigations which shows that some of the things which are reflected in the emails collected from Mr. Jefferson materialize through accused first applicant?
Yeah, there is evidence, like the documents that I had presented to the court yesterday. They were referred in the document, which are the business profiles. And there is also Mr. Stephenson did also talk of a briefing that the applicant used to be briefed as to what is being discussed, or he used to be involved in the planning.
Is that to say Stephenson himself used to brief, or he would
No,
have been briefed by others?
He will be briefed by the others, the co-accused, who
Yes.
used to hold meetings with Mr. Stephenson.
Mr. Marondese?
Yes. The besides Mr. Stevenson, do you have other evidence of what transpired between applicant and these first and these co-accused persons in this matter, which links him to the Namgoma scheme?
There was another on the Nangomal matter.
Yes. Is there another communication between himself? But look, okay, my lord, I think that evidence is
The
on.
question is clear, actually.
Yes.
Yes, the question is clear. Unless you want him to repeat it.
As my lord, he can repeat it.
Yes.
Okay. Is there any other evidence which shows about communication between first applicant and his other co-accused in this matter on the Namgoma scheme?
Yes, there are evidence of the letters from Saki Shangala, which was written to him and the other former Minister of Fisheries in Angola, in which they were talking of a joint venture. There are also evidence of him appointing the Nango Malpesca Namibia, of which one of his co-accused, Mr. Ricardo Gustavo, is a director. That is few that I can recall.
Okay. That communication which you started with when you testified, the letter of the, which covers the, I think the 13th of July, 2013, and the minutes which you presented for that period, and the email from Shangala from that period. Where did you get this evidence from? Was it from Stephenson or you got it elsewhere, from elsewhere?
The minutes, the report and the letter, this was seized from the office of the applicant by the time. So those were among documents that were seized from the applicant's office.
You want me to ask more questions?
That refers to the minutes and what?
Is the minutes, is the report that Mr. Shangala wrote when he accompanied the applicant to Angola. And the request letter for traveling.
And in the email from Mr. Shangala, which is provided as, I think it's part of XX5, where did that email come from, which was addressed to Stephenson, where he was talking about him not having communicated with the Fiti and James?
I allowed him, he's now having a third bite at the cherry. He's now just transgressing into evidence that has already been placed on record, and the witness already testified on that particular aspect, where those emails came from and everything, and we are just regurgitating things that are already on record.
I hear you, Mr. Bierkers, and it may sound as such, but it's in the purview of the court trying to understand really what was testified about these issues by the witness. Because the question was, or as I understood the evidence, literally everything starts to flow from Mr. Stephenson's statement, which is accompanied by emails and documents that were attached. And I then wanted to know, because the witness, when you asked him questions about those, he indicated that it's very possible, or it's possible that they might not have reached the applicant. Yes. So then I was trying to understand from what he placed before court, besides those, what links the applicant to the Namgoma case. And I hear your colleague is talking about an exhibit that was presented before court. So on that basis, I'll find it to be within the purview of the court's question. I don't find it to be new evidence.
No, I'm saying it's repeating the evidence where the documents were obtained from, Your Lordship.
Or repeating.
That is what I'm saying, yes. The witness already testified on length at that particular exhibit.
Then, Mr.
Where the
Marondeze,
email came from.
why then, I would want to know why then Mr. Marondeze is
Lord, I'm
repeating.
just trying to show that to cover the court's concern about if other independent evidence, my lord, besides what
Okay.
Stephen says in his statement.
All right, let me hear that. This exhibit XX5, you testified about it. Apparently, it's the email by Mr. Shangala.
Yes, 20th July 2013, in the early hours of the morning.
Where did it come from?
My Lord, there were emails that Mr. Stephenson himself provided. There were emails that we get from the office of the district prosecutor in Iceland. But what can link the applicant to that email? It's only that during the time when the email was sent, the applicant was together with Mr. Shangala in Angola. And what was presented to the other co-accused, or the content of the email, it was referring to what was discussed. I cannot cannot now recall as whether this email was provided by Jonas Stephenson or it was received through the office of the district prosecutor.
Okay, thank you. Now, these emails from the district prosecutor in Iceland, did they indicate where they got these emails from to you?
Yes, they have explained in their statements how they get those emails.
Yes, can you tell
They
the
have
court?
elaborated the procedure they have followed.
Yes, where did they get the emails from?
There are emails that they get from the server of Mr. Johannes Stephenson. They have also approached, I think the other emails they get them from the Sameri. I cannot recall any other.
Okay, where in particular from Samari? Did they identify where they got them from Samari?
Really, I cannot recall really what is in their statement now. But the emails, they are bearing names from where they were extracted on top. And they are also indicating who are the authors of those emails at the bottom, if I'm not mistaken. Currently, I'm not in a position to say specific from who.
Those are my questions, my lord.
Thank you. I just omitted, I forgot one issue that I wanted to clarify with you. Regarding the board members of the Fiscal board, it appears from your evidence that the first applicant might have engaged other individuals who are not co-accused in this matter to be board members to the board. In your evidence, it sounded as if him approaching any individual to serve on the board is not in accordance with a sound governance system or not in accordance with the law. Is there a problem with him as the minister approaching any person to serve on the board of any entity that falls within the sphere of his ministry? I did not hear your evidence in that regard. You were just sort of insinuating as if there's something wrong about that, but I did not hear you specifically saying whether he was not entitled, whether he was entitled or not to do that.
My lord, the Fiscal Act it have provisions as to how the board have to be elected. And what procedure is to be followed.
Yes, I understand that, for instance, where you testified about the appointment of the chairperson of the board who may participate in that process. But all that I'm finding out, say there are positions to be filled on the board, is it wrong for the minister, for instance, to engage someone he feels can add value to the board to say, are you willing to serve? I just want to understand that part.
My lord, I don't think I do really have a specific answer to the question.
Okay, no, that's fine. I understand that. Thank you. Well, given the reply, I don't think there's anything to re-examine. Mr. Marondeze?
No.
Thank you. Mr. Ganyangela, thank you for your assistance. You are excused.
Thank you, my lord. It was my pleasure to testify before you.
Thank you. Mr. Marondese.
My lord, that's the evidence for the state, my lord.
Thank you. On the way forward, who is to assist the court?
Lord, the next stage, my Lord, is to make submissions before this honorable court.
Yes.
It's the understanding of the parties involved, my Lord, that a transcribed copy of the record is required for that purpose.
Yes.
And the parties understand the difficulties which might be encountered to have the full transcript available before they prepare their submissions. In the circumstances, it's, they understand the parties that it will be practicable to have this matter postponed, first basically for the purpose of ensuring that the record is available.
Yes.
And if the record becomes available earlier than that date, the parties will endeavor to start working on the submissions.
Yes.
And inform the court as such on the agreed date status hearing of the matter,
Yes.
which has been agreed to be the 9th of October,
Yes.
2023 at 1000 hours. If my learned friends are in agreement, may the matter be so postponed for that purpose, my Lord.
Okay. Thank you, Mr. Marantese. Mr. Biakas?
My Lord, I confirm the submissions made by my learned friend. As it please the court.
Thank you. Mr. Siolonji?
So confirmed, Your Lordship.
Thank you. I'm in agreement with the parties that the matter will be postponed for the status on the transcription of the record. That is to enable the parties to obtain the transcribed record and then proceed to prepare their written heads of argument. It was quite a lengthy matter, and the proceedings may be voluminous. So I agree that from now until the next admin break, it's not that long, may mainly be utilized for the transcription of the record, and there may not be sufficient time for counsel to prepare their heads of argument before the hearing, should it be slated for the 9th of October. But what is important is that should the transcription be available before the date to which the matter will be postponed, the parties should start working on their written heads of argument, that is to shorten the period from which we'll postpone the matter on the 9th of October. So as agreed, the matter is then postponed to 9 October 2023 at 10 o'clock for a status on the transcription of the record. The position regarding the applicants remains the same. Thank you for your cooperation and assistance thus far. I'm glad that we have closed the evidence part. Thank you. The court will adjourn.